Good morning to all of you. Interpretation of statutes. In this video, we are going to discuss harmonious construction. Harmonious construction. So, if there are two provisions of law and if they are conflicting with each other, please remember, or if there is any if there is no union, then you have to read them together and then you understand the meaning, because the very purpose of interpretation is to understand the intention of the legislature at the time of making the act. That is more important. So harmonious construction, please remember, the act has to be read as in a whole. The act has to be read as a whole. One part here, one section, one provision says like this, but the other provision says in a different way. So you have to read them together. So the act should be read as a whole and its provisions have to be harmonized, just like harmony. Harmonized, giving effect to all of them. So that means when two or more provisions of the same statute, so they are repugnant with each other, then court tries to construe them. So to give effect to both by harmonizing them. ఒక సెక్షన్ ఒకటి చెప్పుద్ది, ఇంకో సెక్షన్ ఒకటి చెప్పుద్ది. ఈ రెండింటిని కలిపి అర్థం తీసుకోవాలి. దిస్ ఈజ్ వాట్ ఇస్ కాల్డ్ హార్మనీ. రైట్. సో in the case of Krishna Vs Binod 1954, so there was a conflict between section 32 clause 2 of the Representation of People Act as well as 123 clause 8 of the same act 1951. What happened is this Krishna, he was a minister in Odisha state island. So he has won the elections. His election was challenged on the ground that he filed 2 dozens of nomination papers in which the public servants supported him, and this accuser number 5, that is Mr. Vinod, he was a public servant, right? Whatever it is, the main case is that the government servant has supported the candidature. That means nomination లో government servant చేశాడు. Okay. Then he has also supported him in the process of election. Can he do it? No. But as per section 33 clause 2, please remember, a government servant may nominate, a government servant may second a candidate seeking elections. Yes, there's no problem. A government servant can affix his signature as a supporting candidate. But please remember, according to section 123 clause 8, government servant is not entitled to assist a candidate in the election canvassing except his right to vote. అక్కడ 33 ప్రకారము నామినేట్ చేయవచ్చు, కానీ నామినేట్ చేసిన తర్వాత సపోర్ట్ చేశాం కదా అని అతనితో తిరగడానికి లేదు. అర్థమైందా? he has got a right to vote, that's all. He cannot assist the candidate in moving, in canvassing and door to door thinking. He should not do it. సో మరి 33 clause 2 అర్థం ఏంటి? సపోర్టింగ్ అంటే ఓన్లీ సంతకం రాయటం, సపోర్టింగ్ అంటే ఇన్ ఆల్ అదర్స్ కావాలి కదా అని అర్థం వచ్చేటట్లుంది. Now both of them read together. Supreme Court observed that these provisions of law construed that the government servant is entitled to vote and the government servant is entitled to second a candidate. So the candidate now incidentally he became a minister. So please remember, the provision of law has been clarified, harmonized in such a way that 33 and 123 clauses, both of them are correct. According to 33, this man can nominate. According to 123, he should not participate except voting. So this is the beauty of harmonious construction. Shankari Prasad versus Union of India 1951. This is the starting point for the First Amendment. So here the conflict point is whether directive principles are important or whether the fundamental rights are important. All of you are under the impression that fundamental rights are important. But please remember, DPSP, for the welfare measure, for the proper distribution of land or for the welfare of the people, DPSP plays major point. So both of them are equal. Both of them have the same place. No doubt, under part 3 you say that FR has got more value. But both of them have the same value. You should study them together. That's why the government was advised to make law regarding the DPSP so that they can also be enforceable. Is it not? Then, very famous case, Sir Silk Limited versus Government of AP 1964. So there were differences between the employers and employees in the Sir Silk Limited. Ultimately, the matter was referred to the labor court. Labor court effected compromise. But the industry, the people, the workers, they did not want the award to be published. But as per section 17, yes, the award may be published, published. So government says no, industry, the factory people, they say that the award should be punished. But the leaders, union leaders, they feel bad because once it comes out to the union workers, they will blame them. That's why they request them not to pass the award, because they will go and say we have మేనేజ్మెంట్ని మెడలో వంగ తీసామని చెప్పామంటారు. ఏం జరిగిందో వాళ్ళకి తెలియదుగా. ఇదే అవార్డు బయటకు వస్తే వస్తుంది. కాబట్టి అల్టిమేట్లీ ప్లీజ్ డోంట్ పబ్లిష్ ద అవార్డ్ అన్నారు. హియర్ దర్ ఇస్ అ కాన్ఫ్లిక్ట్ బిట్వీన్ సెక్షన్ 17 and 18. Section 17 of the IT Act, the government may give the award. May is not direct. May is only directory. It's not mandatory. కాబట్టి ఇవ్వచ్చును, ఇవ్వకపోవచ్చును. Section 18, compromise is binding on the both parties. So ఈ రెండింటిని కలిపి compromise affected, but government need not, or the industrial tribunal need not publish the award. May అన్నారు కాబట్టి may includes, may not also. So such things do come in the harmonious construction. So please read the topic and enrich your legal knowledge. With this, I am concluding. Thank you very much.